Good afternoon, everybody. And so we're here today for a program. I guess I'll read from the title, What's the Role of Law in Addressing the Clergy's Sexual Abuse Crisis? But here's what we're going to try and do in the next hour and 15 minutes or so. We're going to try and tackle three specific questions. The first is, what is the role of the University of St. Thomas and other institutions of higher learning in addressing this crisis? The second is, what is the role of this archdiocese, both currently and going forward, in addressing the crisis? And then the third, and I believe the most important for all of us, is what are the reasons for hope that we can take away from today in going forward? So format's pretty straightforward. I'm going to do the introductions here shortly, and then we'll open up for questions. There are note cards, I think, around the room. Please write your question on a note card, and the students will collect them at about the halfway mark here, and we'll get to as many questions as we can. So introductions. It's my privilege to introduce all three of these people. Two of them I've known for most of my time here in Minnesota. The first is Tom Johnson. He's a principal at the Great Plant Moody Law Firm. He also serves as the ombudsman for the Archdiocese of St. Paul, Minneapolis, a position that he's held since January of 2018. Tom was jointly recruited by both Ramsey County Attorney John Choi and by the Archdiocese to take on this important role. Basically, he is somebody who's outside the church's structure, who can be a point of contact and a point of support for the victims and survivors of clergy abuse. Tom has also served as Hennepin County Attorney here. He did that from 1979 to 1991. He was on the Minneapolis City Council from 1973 to 1972. He has been on numerous boards of organizations here in the state. He's received numerous awards. I'm not going to list all of them out. I will tell you that he was most recently honored just in this past year with the Attorney of the Year Circle of Excellence Award from the Minnesota Lawyer. He's a graduate of both the University of Minnesota undergrad, a physics major, and the law school. But his most important academic credential is the fact that he's been an adjunct professor here at the University of St. Thomas School of Law. Tim O'Malley, I've also had the good fortune of knowing for many, many years. He, too, is a person with great integrity. Tim was appointed the Director of Ministerial Standards and Safe Environment for this Archdiocese. That was back in 2014. Prior to joining the Archdiocese, Tim O'Malley served as the Deputy Chief Judge of the Minnesota Office of Administrative Hearings, and before that, he was the Superintendent of the Bureau of Criminal Apprehension here in Minnesota. He has also practiced law in the private sector. He's worked for law enforcement agencies at the city, state, and federal level. He earned his JD from the University of Chicago, where he served on the Law Review. He also holds a master's in management and administration from Metropolitan State University. He's published several articles on topics ranging from best practices to ethical decision making. He's also taught as a college professor and as a law conference lecturer. Finally, it is truly my privilege. I have read about this person for many years, but I get the privilege of introducing Kathleen McChesney. She has held unique leadership positions in this country at the Federal Bureau of Investigation, the United States Catholic Bishops' Conference, and the Walt Disney Company, all before establishing Kinsdale Management Consulting, which is the organization she now heads and runs today. At the FBI, she was head of the field office in Chicago, and for anybody familiar with the federal community, you do not realize that is one of the most challenging jobs in law enforcement in this country. She also served as the head of the office in Portland, Oregon. She was appointed Executive Assistant Director for the FBI. That's the third highest ranking position in the FBI, before she agreed to give that up in 2002. After 32 years of law enforcement experience, she agreed to take on the position by the United States Catholic Bishops' Conference to establish and lead their first Office of Child Protection. She developed and administered a national compliance mechanism to ensure that all Catholic dioceses comply with civil laws as well as their own internal policies relevant to the prevention, reporting, and response of sexual abuse of minors. She has a number of other accomplishments. I'm tempted to read them because they are so impressive. She has co-edited the Sexual Abuse in the Catholic Church, A Decade of Crisis book, which describes the actions of the Catholic Church leaders, abuse survivors, and lay Catholics following the January 2002 Boston Globe Spotlight Report. She has served on numerous boards as well and has received numerous awards. I have not ever had the chance to introduce somebody who has received the President's Award for Distinguished Public Service from the United States President. She obtained her PhD in public administration from Golden State University, her master's in public service from Seattle University, and her Bachelor of Science in police science administration from Washington State University. Let's greet all of our speakers here today, and then we'll call on Tom Johnson to lead us off.
Good afternoon. Can everyone hear me? All right. My remarks will assess the role of the law in the clerical sexual abuse crisis within the Catholic Church. However, it is difficult to do that as a practical matter. That is, to assess the role of the law without commenting about the role of the lawyers involved. I'm going to be going light on the latter, heavier on the former. But let me say at the outset that while the history of the church in the United States, the history of the sexual abuse crisis in the United States, has demonstrated too often that lawyers have worked on behalf of the church to frustrate, really, the well-being of victim survivors and, I think, the good of the church. However, there are recent examples here in this archdiocese that demonstrate how lawyers in key positions can work constructively to turn the page in a positive way toward a more responsive, just attitude toward victim survivors. I'll speak briefly to both of these roles of my remarks, in my remarks, but remember they're mostly about assessing the law. Also, as I am prone to do, I'll make some sweeping statements, particularly at the outset. Know that when you've got a complicated issue like this, there's a lot of nuance, and maybe we can get into that in the discussion. But it's not I believe in the statements I'm going to be making. I'm just acknowledging that there's nuance. So let me start with assessing the role of the law. And when you do that, for me at least, it's helpful to understand the circumstances that surrounded the abuse. As I see it from my position as ombudsperson, serving as a resource and advocate for victim survivors, the situation was one of institutional corruption as it relates to the handling of the crisis. That's a harsh term, and I do not use it lightly. And by it, I mean that the conduct was sufficiently dishonest, it turned the morality of the situation on its head. I believe there are 4 key elements of this corruption as seen from a victim survivor's perspective, knowing what is now known. First, a sizable number of clerics participated in the abuse, suggesting to victim survivors that the abuse was tolerated as part of the institutional culture of the church. 2, as specific clerical abuse situations became known internally to the church, the diocesan hierarchy inevitably became involved with the offender, the clerical perpetrator, and often with the victim. When this happened, most victims thought the church would be fully on their side as a protector. However, the diocesan involvement nearly always sought to protect the reputation of the institution, that is the church, and often that of the cleric, at the expense of the victim's voice being heard and acted upon. The result was that the victims felt isolated and marginalized, not protected. Finally, for victims who continued to press for attention, they would often receive a modest monetary payment in exchange for signing a confidentiality agreement with the church, thereby becoming an integral part of covering up the abuse that they had sought to expose. So, there you have it. Children who were criminally abused by individual clerics were then, in my view, insidiously marginalized by the institutional church. In fairness, you could say that the decision makers believed they were acting in the best interests of the church. But the mission of the church is to assist people on the margins of society. It's not to be the cause of their marginalization. Such an inversion of the moral order leaves no room to wonder why the harm to victims, the physical, emotional, spiritual harm, was so deep and long-lasting. Let me move on to how the law applies to an institution such as this, one that has this element of corruption running through it. Initially, of course, it doesn't apply. So long as the abuse remains a secret within the church, application of any law that would reveal the secret will be ignored. Lawyers were, of course, on the scene. We're talking about the 50s and 60s and into the 70s, maybe the 80s. To assist, lawyers were on the scene assisting with assessing potential liability, drafting the confidentiality agreements, and providing related legal advice. But all of this was done under the guise of the attorney-client privilege, which ensured the continuation of the church's secret through the confidentiality protection that privilege provides. In doing their client's bidding without questioning its morality, lawyers contributed to the institutional corruption with the church and thus to the harm of the victims. Ultimately, the truth did come out, as it invariably does in an unjust situation. This positive development was precipitated by the public more fully grasping the evil of child sexual abuse rather than a change in the church's position. This led just the same to individual clerical abuse victims coming forward to speak publicly about their abuse. As individual victims came forward, they started to organize. You had organizations such as SNAP that came into being. Whistleblowers within the church revealed what they knew. In our archdiocese, the name Jennifer Hasselberger will bring back memories. Finally, law enforcement and prosecutors took note of the situation and began to make inquiries. The cat was finally out of the bag. At this point, the church could no longer ignore state law governing the reporting, investigation, and prosecution of child sexual abuse. But as I will now discuss, the law has parameters which left open the extent to which the church needed to take affirmative action to uncover and disclose the nature and scope of the past abuse. On this moral and ethical question, our archdiocese broke new ground, and that ground is favorable, quite favorable, to victim survivors. So what laws were in play? There were two principal laws in play. Both are in Chapter 609, which is our criminal code. The first makes child sexual abuse a crime punishable by increasingly greater levels of severity depending upon the egregiousness of the conduct involved. The statute of limitations for prosecuting such behavior varies depending on the circumstances surrounding the abuse and actually when the abuse occurred, because the legislature was continually changing the statute and providing for a longer and longer statute of limitations period, allowing longer periods of time to bring a criminal action as time went along. The second law requires professions such as teachers, social workers, child care providers, and members of the clergy to report child abuse if they know or have reason to believe that abuse is occurring or has occurred within the previous 3 years. If the abuse occurs prior to 3 years from its discovery, there is no legal obligation to report it. You can report it, obviously, voluntarily, but there is no legal obligation to report it. And I hope this isn't too convoluted, but the statute of limitations with respect to reporting child abuse is also 3 years. So you have, if you discover the abuse within 3 years, you've got to report it. You can be prosecuted for not reporting it unless within that 3-year period when you first discovered it, you immediately reported it. So you can stretch this out 6 years. There's a 6-year window in which there is vulnerability for having failed to report child abuse. The Archdiocese could have operated within these statutory parameters. It instead chose to go beyond what was legally required. Rather than simply taking stock of cases meeting the know or reason to believe standard and reporting those cases to law enforcement, if they were within the applicable statute of limitations. The Archdiocese brought in Kathleen McChesney and her team to review all clerical sexual abuse cases that had come to the Archdiocese's attention where the subject priests, at least this is their initial review, where all subject priests were still in active service, regardless of how long ago the abuse had occurred. The Archdiocese also decided to report all cases to law enforcement for which there was credible evidence of abuse. And credible evidence was defined to mean any case in which the allegation of sexual abuse of a minor bears a semblance of truth and is not manifestly false or frivolous. That is a very low standard. And the adoption of this standard resulted in many more cases being reported to law enforcement than would have been legally required under the know or reason to believe standard. Finally, and I think very importantly, the Archdiocese acted on a suggestion by Father Dan Griffith, who was then the delegate for Safe Environment, to professionalize the internal investigation of alleged abuse cases. This is where Tim O'Malley and his staff enter, bringing a level of professionalism and integrity to the investigative and priest sanctioning process that was sorely missing when those internal investigations were conducted by a fellow priest who very likely had no investigative training or experience and was working part-time on the job. This is a night and day difference from a victim's perspective in how allegations of child sexual abuse, clerical abuse, are handled here. Now there is a capacity and I would say a determination to uncover the facts fully and fairly while providing the victim with respect, victim survivor with respect and dignity in the process. One other law and the creative lawyering around its use contributed significantly to further accountability and transparency within the Archdiocese. Ramsey County Attorney John Choi, who I don't see here, made use of a civil statute that allows the county to intervene when a family or here an institution fails to protect children under their care. This lawsuit resulted in a 24-page settlement agreement, which is full of lawyering motivated by a common desire to protect children and bring greater accountability and transparency to how this would occur going forward. Joe Dixon, who was the lawyer for the Archdiocese, is here. Are there anyone from the Ramsey County Attorney's Office? I don't see John Choi. Thank you. I don't know, were you involved in the negotiations? Good. Well, I think this is an example of how the law can be used in a creative way, in a way that really turned a new page for our Archdiocese. I was going to recite some specific provisions in that agreement, but I'll forego that because I'm going to be running out of time here. The only one I will mention is that agreement creates the ombudsperson position, which I'm now filling on a voluntary basis, beholden to no one other than victim survivors. And then lastly, there obviously was a role for litigation. We know about the $210 million settlement. In that the litigation piece of this really was significantly enlarged once the legislature opened an opportunity, a window within the statute of limitations for civil lawsuits to be brought. Many were, and those victim survivors are sharing in a $210 million settlement. The attorney there was Jeff Anderson, and he represented many of the victim survivors, and I would say his persistence and passion paid off. Is all the heavy lifting done? No, by no means. Two areas I think in particular need continued attention. The first concerns outreach to victim survivors. Archbishop Hebda has communicated through the Catholic Spirit and perhaps other sources his willingness to meet with victim survivors. Commendably, he sets aside time on his calendar to do that. And as I have witnessed, when he does meet with victim survivors, he's very, very good. He communicates his support in both by words and body language. But I think the outreach still needs to go further. For example, many of the victim service survivors who were plaintiffs in the civil lawsuits and have a monetary recovery coming their way would still like the Archdiocese to extend a personal apology and acknowledge the harm that was done to them. Another action critical to rebuilding trust within the victim survivor community is for the Archdiocese to deal fully and transparently with what I will characterize as a mess surrounding former Archbishop Neinsted's alleged misconduct. Misconduct while he headed up the Archdiocese here and during his time as bishop in the New Ulm Diocese. For victims, the Church's response to clerical sexual abuse will lack integrity and accountability so long as those in the Church hierarchy play by a different set of rules than do priests and deacons. This needs to be fixed and fixed soon. It should include, in the case of former Archbishop Neinsted, full disclosure by the Archdiocese of Neinsted's alleged misdeeds with appropriate attention given to protecting the identity of the minors, and then a determination as to whether the allegations are substantiated. Here, we're talking primarily adults, victim survivors, and when that's the case, we have a different set of laws that come into play. But in determining what's the appropriate legal response. But in my mind, the ethical and moral analysis remains the same, and that should be the first thing that is decided upon. What is the correct moral response here? What's right and just? So in closing, I would say this. The law is and should always have been relevant to how the Church responds to clerical sexual abuse. But the role of the law is secondary to the Church recognizing and fulfilling its moral commitment to do what is right and just. Without that coming first, the role of the law will always be shortchanged. This doesn't mean there isn't a role for lawyers. There is. Lawyers should be involved, in my view, in helping the Church recognize what is right and just, which involves acknowledging, determining, recognizing that the Church's moral responsibility runs far deeper than for any other corporate or institutional client. When you're representing the Church, the Catholic Church, any other church for that matter, but we're talking about the Catholic Church, you have to acknowledge that you've got a client that's very special. If they're going to have moral authority, they have to act with moral responsibility. Once that morally correct response is identified, there is a role for lawyers for good, solid legal advice, creative advice at times. But that advice needs to be consistent with the proper moral framework. The Church hierarchy has dug a deep hole. And they need, that's not mine, it just sounds like mine. Let me start. This is my last two sentences. The church hierarchy has dug a deep hole, and they need help. Serious, well-intentioned help from faithful, concerned, talented laity to change the culture that tolerated criminal acts of sexual abuse for far too many years, and then marginalized those who had been harmed. There is plenty of room for lawyers and others, but particularly lawyers, to help the church do this. Thank you.
I get no respect from any law students ever. Thank you for coming this afternoon. I want to thank the University of St. Thomas for pulling this together. I really appreciate it. Tom mentioned that he was going to focus on the law and not as heavily on the role of lawyers. I'm going to do just the opposite. I'm going to focus on the role of lawyers. And I'm going to try and do that in this way. I think there are two types of lawyering that I'd like to identify. And then talk about those two skill sets in the context of looking at it from the client's perspective, which is what I was and the Archdiocese was in the issues we're going to talk about, and demonstrate that by talking about a couple key decision points in the last 3 or 4 years. The first type of lawyering, I think, is what everybody would think of as lawyering. You know, being a lawyer 101, dealing with legal issues, criminal law, civil law, constitutional law, whatever it might be, analyze those issues, the statutes, and then give advice to your client on how to proceed with those legal issues in mind. The second type is going well beyond that, going well beyond the kind of myopic viewpoint of, I'm a lawyer, I went to law school, I can tell you things that you don't know about the law, and actually trying to work with a client to understand their mission, to assist them strategically to accomplish a greater good than might otherwise come out. So on the first issue, the Archdiocese was in bankruptcy, faced criminal and civil charges. Those issues got fairly complex because of the interrelatedness involved in that. But still, they were right in front of us. I think lawyers with a certain skill set could analyze that and come to certain conclusions. What gets lost in that, though, I think, is the legal analysis, is the greater good, if you will. And in this case, that question came down to, what is justice? What is justice? The kind of thing you talk about in law school, but doesn't always get a lot of practical addressing in the real world, I don't think. So you break down the first issue, and I kind of want to remind you of the backdrop of where we were. I started in the Archdiocese in the fall of 2014. About 2 months later, the Archdiocese declared bankruptcy. I'll tell you a quick aside. My mother wasn't thrilled that I took this job. I had a very steady government job. And she said, why are you, and she's a devout Catholic, but why are you getting involved? I just think it's ugly. I don't like it. So then, she's in her 90s, so then I called her one day when she read about the bankruptcy, and she said, and now you're not even going to get paid. I told you this was a bad idea. So the Archdiocese declares bankruptcy in about January of 15. 6 months later, the Ramsey County Attorney's Office files criminal and civil charges against the corporation, and that's an important factor, not against any individual, but the corporation as an entity, as Tom described, was basically a criminal enterprise, that they failed as a corporation to adequately protect children and to contribute to their delinquency. There were 6 separate charges in that filing. There were 3 victims of Curtis Waymeyer. Each victim had 2 charges related to the conduct. Curtis Waymeyer is the priest who sexually abused children, is rightfully so in prison today. But you looked at those charges and the failing to protect and the delinquency, and the area I want to focus on is the first decision point is, what do we do when that came out? I have to tell you, frankly, it was unexpected on that day that it would be a corporate charge. We didn't see that coming. And if you put yourself back in that moment, you're trying to think, all right, what should our initial response be? What should our approach be to handling this? And this is prior to having a defense attorney or some other attorney working with us at that point. There were really two options, I think, in front of us. And there was strong advice going in each direction. One was there was a lot of wrongdoing done. In fact, there was criminal activity, no doubt. Curtis Waymeyer abused children. And there was wrongdoing at the highest levels of this archdiocese, without any doubt. So some said, listen, you have to just own this thing. You have to get up and say, yes, we're guilty, we did it, and that's the only way that we can move forward in any kind of a positive way. There are others just as informed and just as well-intended saying, whatever you do, don't admit guilt. Don't admit criminal liability. And there's a couple practical consequences that relate to that came to the surface right away. One is, at the end of the day, and I think somebody already mentioned, there's $210 million in the bankruptcy that is now in the hands of victim survivors. Rightfully so. Maybe inadequate, but they were compensated in some way. 170-some million of that was insurance money. Okay? That's a lot of money. That's a lot of money. If you think for a moment about insurance law and the way all these different legal issues could come into play, and I will tell you that when I talk about the complexity, there was bankruptcy law, torts, insurance, criminal civil, canon, corporate, employment, ethics, ad law, contracts, constitutional law, and then the insurance I talked about. Some of those all played a role as we were trying to sort out these three things. And I don't know that there's another archdiocese in the country that was in bankruptcies, criminal and civil all at once. So it got kind of complex, right? But again, we're looking at that and figuring it out. Insurance law, if you think about it, there's two parts of that are important. One, you have a requirement, if you have an insurance policy, to cooperate in the defense if something is brought against you as an entity, right? That's contract law. You have a responsibility. So the insurance companies would say, wait a minute, you've got to help us with our approach. So that's one issue. The second issue in bankruptcy, in insurance, your insurance will cover it unless you're criminally liable for what happened. Think of it in terms of arson. If your house burns down, the insurance company is going to pay for a new house. Not if you struck the match, though. Right? That voids the policy. You can't do that. So there's an argument. We didn't know the answer at this point. But day one, there's an argument that if you get up and say that as a corporation, you are criminally liable, that will void all your insurance policies. And we had insurance policies back from the 1940s up through today. Again, that ended up with that much money. So day one, we're trying to figure out what can we do? What should we say? How should we act and respond to these charges? The issue was not to decide that right at that point. People had come and said, you can't say that you're guilty, and I looked at it and I said, listen, I don't know if we are or not right now. I don't know these statutes. I don't know all the issues that might come up into play in this, and we need to look at that. So before we make a decision on that, we're going to have some legal analysis done on the actual case. And the way we did that, if you think about it from the other side, and this doesn't merit a lot of discussion, but I want to point out the other side as you're going to get to your lawyers and get advice. This is a corporation charged with 6 misdemeanors. So the first thing you have to do is look at the elements of the crime. Was there a crime? I mean, I said before, absolutely there was criminal activity. But is this corporation guilty of the specific charges leveled that day? And to this day, I will tell you Ramsey County and I probably disagree on that. Okay, and I'm going to get to where the role of litigation came into this. But that's something we had to look at. It's the old, from law school, those who left, it's the mens rea, the actus rea, proximate cause, real, all that kind of stuff. You got to look at all that. The second issue that came up right away was the First Amendment. There's canon law involved. Can the government insert canon law into their analysis and hold people in the church liable for criminal conduct based on something other than statute? And how does that relate? And lastly was the corporate layer. If you think about it, corporate liability is very different than individual liability, right? Corporate liability generally requires that a corporation is responsible criminally if there's action by an agent of the corporation, okay, if that agent acts within the scope of their employment and they have the authority to take that action. getting maybe more in the weeds than we have to, but the fact is in Minnesota, the Archdiocese Corporation is an entity. All 187 parishes are their own corporations. Priests, Curtis Waymeyer, is not an officer of the Archdiocese. He's an officer of a corporation that's at the local level, and that's based on 1,800 statutes in Minnesota. So we had to see, was there an agent? And then was that action in furtherance of corporate interest? And lastly, were the criminal acts known to the corporate management and were they ratified or approved by management? So you start breaking that down. Curtis did this stuff, but as the Archdiocese Corporation, did he have the authority to do that? Did the highest levels know? So we're trying to think through this, and then you get to the practical aspect of what do you do about it? So on day one, what we decided to do was stand up and say basically three things. We said, again, not knowing the answer to this yet, we got up and said, we have a lot of respect for the Ramsey County Attorney's Office. That was true then, it's true today. We have a lot of respect for the criminal justice system. That was true then, that was true today. And we pledged to cooperate fully in the investigation. That was true then and that is true today. That's as far as we could go. The second key decision point is picking an attorney then. So now we're deciding on our approach. How do we go about doing this? And we really, again, had two choices. And we had attorneys come in and we talked to them within the first couple weeks. The first approach was the more traditional approach. And what I'm going to get to is what Tom's talking about. You know, you can do the traditional lawyering 101, or you can try to be a little less traditional, a little more creative. So the first approach offered to us was you need to fight this, the stuff I just talked about. First Amendment alone. You need to paper Ramsey County with motion after motion. Take them out of their comfort zone, get them arguing about corporate law, and get them arguing about First Amendment. That's not their area of expertise. You need to fight this. You can't admit this. It's too devastating to the church and so on. The second approach was obviously the one we chose at the end of the day, but it was to try and come up with an attorney and an approach that saw what I described at the beginning, that saw a greater good, if you will, that would have the skill set to do the lawyering, but that would know their role and could provide advice and maybe come up with a different answer to what is justice than what most people would generally think. So then we ended up, and again, I think part of what was driving that is we came to an early conclusion in the Archdiocese that Ramsey County was very genuine, that they would with time have an interest in trying to achieve that greater good, and that if we work through the litigation is not the end all. Litigation is one tool on a path to justice. If people went into it thinking, if I win this motion or if I win a trial, that's success, that may not be the best way to measure success in a case like this. We need to look at what the consequences are and decide how to move forward, and hopefully down a path that we would litigate, but everybody would have the mindset to be open to an ultimate solution that might look very different than what we thought was even possible on day one. To accomplish that, we went with Joe Dixon as our attorney, and I think at the end of the day, he deserves a lot of credit. He is a very well-seasoned, skilled attorney at dissecting the legal issues and understanding complex legal issues, but he also added an ability to grasp the big picture and to know his role and to offer advice to us as clients that would take us in a strategic way to a different outcome. I also want to, very clearly and publicly state that a ton of credit goes to John Choi. He had a similar attitude. He didn't just go into it thinking, we've got to get a conviction. That's how we all started, and that's the litigation path we went down. But he and John Kelly, his assistant, and Stephanie Wiersma, who's here today, and Tom Ring, the four of them were really very bold. And I know I know the pressures in our office. I can imagine the pressures in theirs. I will tell you, if you've read the complaint, they did a phenomenal job of painting a horrendous picture. I mean, it's a complaint, but if you read that, I want to convict the church. It's like, oh my God. You think about the stuff that happened. How can they possibly say they didn't do anything wrong? Well, you get back to that lawyering part of 101. All right, is this the right? What's the outcome we want to get to? But they did a great job. having done that, they were aggressive, but they were smart, and they were open to other approaches. So that was the attorney selection. A couple of other just brief comments, other areas where I think we took a less than traditional approach. And it was risky, and at the time, we were thought to be very foolhardy. At the end of the day, I think it's worked out well. You can make your own, draw your own conclusions. But at one point, we settled the civil charges, the civil issues with a settlement agreement with Ramsey County at a time when the criminal charges were still pending. Now, most lawyers would tell you, you have these things that are parallel, and you just agreed to the 24-page document where you're going to do all these things. You're giving up all kinds of rights. You're doing all kinds of, the First Amendment stuff's out. You're saying you're going to do all that, but the criminal is still pending. You've lost all leverage. You've lost all negotiating power. People thought we were just absolutely stupid to do that, and they made that known. I think at that point we had a certain level of trust and communication with Ramsey County that we hoped that in the long run we would all be fair and figure it out. But that was a very risky proposition at the time. They could have just hunkered down and said, you know, if you don't plead guilty to something, we're going to go to trial and we're just going to keep going. The last decision point was, and this seems like a minor one, but in hindsight it really worked out well. When we got to trying to resolve the criminal aspect of it, and this was again I think very good lawyering on both sides, we ended up using 2 mediators. And a lot of people had said they tried that once, or maybe have never tried it, didn't think it would work. Most said you need to have one strong-willed, smart mediator who can help you achieve some kind of a compromise or an outcome. They thought we were idiots for using 2. We went with former Chief Justice or Chief Judge in the federal court here, Rosenbaum, and then at Ramsey County Court, the former Chief Judge there, Kathleen Guerin. And they had never done this together. And we talked to them about it. They weren't sure it would work, but it worked very well. And they had certain skill sets, certain experience, both in federal because of the bankruptcy and the other things, and then in state court, they understood it, and they helped bring us together for a solution that I think was better than ever could have happened if we had just gone a different route. A couple last comments. At the end of the day, I think the lessons learned for us, one, or for anybody who wants to be involved in these types of cases as a lawyer's perspective, don't lose sight of the mission. Don't lose sight of what goals can be achieved in the midst of very difficult legal times. Therein lies the opportunity to do something that otherwise might not be attainable. Secondly, keep attorneys in their place. They are not decision makers. And it's always been an aggravation, a pet peeve of mine throughout my career in law enforcement, where you'll talk to somebody and they'll say, I talked to my attorney and they said, I can't sign that, I can't talk, I can't do this, I can't do that. No, your attorney gave you that advice. You make up your own mind. Because again, we had attorneys with solid advice, good advice, and we chose to ignore that sometimes. And then the third thing would be solutions in these types of cases, I think, can never be driven by the legal issues alone. And if somebody got in their mind that the way to win is to prevail in litigation, that's one way to define success. I don't think in these cases that's the right way to define it. I think there are greater goods that can be accomplished if you are open to doing that. I would also mention that I think the attorneys involved, from Ramsey County and ours, I mentioned, and the bankruptcy attorneys, Charlie Rogers and Lauren Lonergan from Briggs, you know, these things all rolled around together, and it really took attorneys on all sides to remain open and to not be selfish, to not let egos get in the way, but instead step back and think, where could this take us in the very long run? The last thing I'll mention is Tom mentioned some of the progress that has been made, and there's a lot still to do, no doubt about it. But I think a fair amount of progress has been made here in terms of certain processes and putting people in place. And the victim survivor community's involvement today is unprecedented, I would tell you, compared to other dioceses. There's a level of the goal at the end of the day, I think, was to accomplish. Ramsey County and the Archdiocese agreed that what we needed to do was hold the Archdiocese accountable. When they just agreed to dismiss the criminal charges, the Archdiocese admitted to wrongdoing. The Archbishop got up and apologized and explained, yes, at the highest levels, the Archdiocese failed to protect children, period. Very specific admission. What we didn't admit to was the specific crime charged, right? But that doesn't mean that there wasn't outrageous wrongdoing by leaders in the church and by certain priests. But the other thing that came out of that was Ramsey County insisted and got, and actually we've benefited from it, a level of accountability that would have been unprecedented moving forward. We have the audits by outside entities. We go to Ramsey County every 6 months for 4 years, report to the judge, go in, swear this is what we're doing. They hold us accountable. And I think that's a bigger success in terms of both accountability, looking back to the wrong that was done and holding those priests and others accountable, and also the prevention efforts of today. It's all done with an agreed upon aspirational goal of changing the culture. Not just having one or two things go right, but changing the culture of an institution that was flawed. So I think at the end of the day, those are the things that will hopefully live and will result in, as a result of good lawyering, will result in changes that will last for generations to come. Thank you.
No? Can you hear me in the back? Okay, good. Good, thank you. And thank you, Lisa, for the invitation. Thank you for the wonderful introduction. Now everybody knows how old I am. So we could set that aside. But it is a pleasure to be here and to once again hear the incredible progress and the incredible story that the Archdiocese of St. Paul has to tell. The confluence of problems and issues that were going on here in the Archdiocese back in 2013 and 2014 were unique in the country. They were challenging to not only the leadership in the church, but to all the lay employees of the Archdiocese, challenging to the lawyers. And the things that have resulted are an incredible model for the rest of the country in terms of if you keep your eye on the mission, what it is that your goal is. People of different opinions can come together with a good resolution. And in this case, people remain focused on what the victims, survivors needed. And that was the most important thing of all. And I would hope that in other places that are experiencing similar things, and there have been nearly 20 bankruptcies of Catholic dioceses around the country, that they can learn from all of this. And I know at least a couple of dioceses who have looked to you already for assistance and guidance on how all of that went down. I just want to talk a little bit, this is about lawyering. I'll talk a little bit about the law and then give you just a little bit of background on the church structure and how that fits in with all of this, and some things that really haven't been discussed here today that might be of interest to you and informative with regard to how dioceses, how religious communities deal with these problems in the future. And I also want to say that if there's anyone in the room who has been the victim of abuse, has been abused, I apologize for I don't have to apologize for the church, but I am sorry for what has happened to you, and I hope that nothing I say will further your pain. The sex abuse cases that we talk about, the hundreds of lawsuits around the country, are occurring because the church had so many endemic failures. The civil law, the civil courts, the civil system, the criminal justice system is now the default response to when people come forward with allegations of abuse. Now, where there is abuse that is criminal abuse, and much of it is, then those cases, I believe, because I come from a law enforcement background, those cases should be reported to law enforcement. But I can tell you from my experience with lots of survivors, from looking at many records going back literally over 100 years, that there have been times that people have come forward with complaints who have not wanted to pursue the complaint in the criminal justice system or even the civil system. All they wanted was an apology and for the offender to get help and perhaps be moved, be put in a place where they could never reoffend. So the church often took on that role, and parents would say, we do not want to go to law enforcement. Why? We don't want to hurt the church, even though the church has hurt us, and we do not want our child to go through the criminal justice system, to go through the court system. When the Spotlight movie, the Spotlight investigation came before the movie, but when that Spotlight investigation was going on and people were learning that about all the abuse that had occurred, some of those writers found it just incredulous that, what do you mean that people wouldn't want justice? What do you mean people wouldn't want their day in court? Well, in 1952 and 1963 and 1978, there were people who did not want that type of response. They wanted the church to respond the way the church should respond, in a pastoral way. They wanted the guy out of ministry. And unfortunately, some of the promises that were made, yes, we will take this man out of ministry, yes, we will get him help and therapy, some of those things were not true. And so now that people have learned that some of the promises that were made, or many of them, were not true, the hurt is even deeper. And that brings on, the second sort of shame. There's the shame of the abuse that a cleric, that anyone acting in any ministry of the church would abuse a child. That's beyond horrible. But when you think about the fact that they may have been enabled, that there may have been cover-ups, and we already know that there have been, that just increases the pain exponentially for the men and women, boys and girls, and of course their families. They were lied to, and that was almost as bad for many of them as being abused. So the sex abuse cases now are being defaulted, if you will, but into the proper way that they should be handled, and that's in the criminal courts if someone has abused a child. The civil courts, where the civil law allows a lawsuit to take place, and there have been a number of changes over the past couple of decades with regards to the laws of statute of limitations, what you can bring forward in civil court and what you can bring through from a criminal standpoint. The church did, many people, many leaders in the church did have a lack of understanding about the problem, but that's no excuse for lying to people who came forward, for not believing people who came forward. And then there is the entire issue of canon law, which would be, days worth of conversation here. So I won't go into this much other than to say that from a civil standpoint and a criminal investigative standpoint, there is a lot of confusion about what canon law is and isn't, and what it can do and what it can't do. And it is really ignored, as it should be on the criminal and civil side. Police don't care about canon law. They really don't. They care about someone got hurt and how we're going to investigate it and how we're going to get it to the prosecutor and what's going to happen to the offender. The fact that it's a grave delict, or the fact that it is violation of one of the Ten Commandments. They don't care. It has to do with what happened to the child. There have been a number of bankruptcies, as I mentioned before, and we had a discussion earlier today about bankruptcies and about money in the church. Bankruptcies have had a way of cleansing a community, cleansing a faith community. If you have to start over again, you can look at that as a chance to be a better church, to be a better community, and to recognize all the people who are able to help you get through that issue. Certainly you don't want to have a church that takes advantage of the stewardship and the contributions and the donations of people who've worked very hard for their money. But you really want to recognize that there is a chance to move forward. There is church beyond bankruptcy. Another thing I'm going to step back a little bit to understanding the lines of authority in the church, which is sometimes hard for criminal investigators and for civil attorneys if they don't really realize that the church is not one big church in the United States. It is 195 different dioceses and 200 different religious communities. So if you sue one, you're not suing all of the communities. You're not suing the church in the United States. I think one of these gentlemen mentioned that parishes are incorporated differently. A diocese is incorporated differently. If you're involved in any kind of legal interaction with the church, you had better understand how the church is organized. And it's organized in 195 different ways in the United States, and every bishop reports only to the Pope. So you can't go to somebody in the United States and say, well, you're the boss and we think something's going wrong in St. Paul, or we think something's going wrong in Winona. You have to deal with your local bishop, your local community, or your local religious superior. So I'm getting the high sign here because I'm sure Tim O'Malley took up most of my time, but but he's a lawyer and I'm not. So let me just say this for all of you. Some of the questions of the day had to do with what institutions, law schools, Catholic universities, Catholic colleges should do relative to the issues of sexual abuse in the Catholic Church. And I can't emphasize enough that these entities can be very instrumental in providing research that needs to be done. They need to keep the conversations going about these issues because sexual abuse in the Catholic Church, while has been reduced substantially over the last 30 years, it will always be with the church because the church is part of society and child abuse will always be part of the framework because some people will abuse. Hopefully a smaller and smaller percentage of people. The other thing is I think the institutions have a responsibility to teach the history of abuse to its future lay leaders so that people will know and understand how do you correct things and how do you have a better future if you don't understand what went on in the past. And there needs to be more education and more understanding about why these cases occurred. And with that knowledge, we can all go forward and prevent as much future abuse as we can. So thank you very much. Thank you for the heads up on my time running out. And I turn this back to Lisa or to Hank.
So I have some questions here. Anybody else, please hold them up and they'll be collected. This first question I think is for everybody. The purpose of the church is to witness to and to be the continued presence of Christ in the world. There is no doubt that new policies have created a safer environment for children. At the same time, many good and holy priests are fearful of being too warm, too friendly, or loving towards their parishioners and towards children. This is disastrous for the mission of the church. How do we support our priests in living their vocation in the midst of this crisis?
Well, I'll take the first shot, and I would
Go ahead.
assume, Kathleen, I disagree with the premise of the question that this is disastrous for priests. I think it's a part of the society we live in today. I coach children. I'm never alone with them. It's not a requirement. I have neighbors who have young children, and one was over not a while ago, or a little while ago, and we're playing outside, and I had a Nerf football that my kid had, and I looked at the young boy and I said, you can have this football if you want, if it's okay with your mom. You involve the parents in it. I don't just, it's a different way of dealing with the world. I think there's still room to be affectionate and to do things the right way. You just have to be smart about it. I don't think, it's different for priests, and I get how it was done before, but the other thing to keep in mind is, I grew up in the Leave It to Beaver day, right? The doors were unlocked, every neighbor knew you, everybody knew each other, and it all seemed great. We lived in this wonderful society. Well, the truth is, underneath that calm surface, kids were getting sexually abused a lot. I'm not just talking about the church. The statutes you talked about before, it wasn't until the 90s that people had to report that they had mandatory reporting on abuse. Back in that day, law enforcement's response, others' response were, you got trouble with that kid at home, take them home, parents deal with it. Sometimes you were putting a kid right back in the home where they were being abused. A lot of stuff was going on in those days when we all thought it was idyllic. The truth is it wasn't. So we need to be, heightened awareness is a good thing.
Tom or Kathleen, anything else?
Well, I think this speaks a lot to the continued need for abuse awareness education. There is a difference between abusing, grooming, and proper contact with young people. And people now are becoming very much more aware of what grooming looks like, so that if you see someone who is acting improper around a child, that it can be addressed. And sometimes it's just a matter of providing more counseling and training and oversight to the cleric. Sometimes if you have a problem such as someone who's a pedophile, you can't fix pedophilia. You would just have to address it and see what you can do to control that person.
A couple of things. One is that I think there is some semblance of a black cloud over priests, and that's very, very unfortunate. Some data that I was just given this morning says that the number of priests that are involved in abuse is estimated at 3 to 6%. It's not insignificant, but that does leave somewhere between 94 and 97% of the priests that aren't, and that there needs to be recognition of that. One, and two, I think we can do a whole lot better job, and need to, in giving both kids and adults the proper language to talk about touch, physical touch, and knowing, that there is touch that is loving, that's appropriate, and for kids, go with that, but trust your instincts when you feel uncomfortable, and talk to someone about that your uncle or teacher or whatever, just he touches me in a way that I just don't like. We can do a better job at that, and I think that needs to be incorporated into what we're doing going forward. What's the best practice about getting people comfortable about talking regarding touch, and the grooming issue, it looms out there as well, as knowing when that's happening.
So we've got several questions dealing with Ramsey County and the Ramsey County Attorney's Office, and I want to give an acknowledgement to Stephanie Wiersma, who's a graduate of this law school, who was part of the team that was involved in that case. But to try and synthesize this, and I think we'll start with Tim O'Malley, but I invite the others to comment. It's hypothetical, but if Ramsey County and the Ramsey County Attorney had not prosecuted the Archdiocese and brought the civil lawsuit, do you think that Archbishop Nienstadt would still be the Archbishop in this Archdiocese? And why don't we leave it at that?
Thanks for the easy one. Well, this is my personal opinion, I guess. I don't think he would be the Archbishop today. I don't think he would have resigned when he did. He resigned, and so did Bishop Pache 10 days after the criminal and civil charges were filed. No doubt that was a huge impetus to his leaving. So I think that at the end of the day, while I wouldn't wish this on others, the fact that starting with the bankruptcy, but both the civil and criminal, what Ramsey County did forced the hand in a lot of ways, and it resulted in a very healthy look, and it resulted in changes that were needed, and it gave us the opportunity to try to correct things and maybe build some trust and try to get back on the right track, try to get between the white lines again on the highway. And if not for their actions, then this archdiocese would be nowhere near where it is today. And we got a long ways to go. Don't get me wrong, I'm not claiming success by any means. But Ramsey County, to their credit and to their bold and courageous actions in pushing this as hard as they did, along with others that were mentioned earlier, people that pushed the envelope before it was popular, SNAP, others. This is not going to go away. And there was people when it wasn't the popular, if you will, issue today to come in punching. There were people that were punching back in the day, and thank goodness they were.
Anybody else? So this is a question for all three of you, and I'd like to sort of preface it by saying one of the 3 points for today were reasons for hope. So maybe you could try and weave your response to this question in for reasons for hope. But this is, you've encouraged Catholics to get involved. When I think of lawyers getting involved, the first thing that comes to mind is somebody suing the archdiocese. Do you have recommendations for ways that lay Catholics who care about these issues can get involved and help the archdiocese move forward and heal? Kathleen, want to go first?
Well, you talked about moving forward and healing, and I sort of circle back to prevention as well. But there are lots of opportunities. You can be a lawyer and also a volunteer for your church. The programs that we've been talking about, the abuse awareness programs, they're required of every educator, every volunteer, every cleric, every seminarian in every diocese across the country. And they need good people to come in and volunteer their time to teach those courses. And it's a little bit of a slog, but it is good work in teaching moms and dads, teaching the clerics what it is to, what the signs are of abuse, what to do, how to teach people how to respond, who to report to. I think that there's an opportunity there for attorneys who want to volunteer. As far as the healing process, I think that the Archdiocese has some opportunities there. I'll defer to Tim on that.
Yeah, I think we had a discussion this morning about the role of the university here, and it was a very healthy discussion. And I think one of the approaches that I think everybody would agree with is that the change in the church today, in my mind, that is most significant in terms of promise for the future is the role of laity. Clergy are critical, but the day when the priests knew all and everybody just blindly followed are long gone, and it should be long gone. There needs to be a partnership with lay people. Everybody talks about fairness, accountability, and transparency as 3 goals. Who's opposed to fairness? Raise your hand. Of course, everybody wants fairness, right? But what does that really mean? And I think long-term accountability will be in place, not because of certain rules that are here today that we're demanding be followed, but because lay involvement is there and the odds of regressing to the old ways of clericalism and just the church is good, they must be doing good things. The safety net for that is lay involvement and real involvement. And Kathleen mentioned a couple of them. I mentioned earlier, every parish, 187 parishes, are all separate corporations. So every corporation has a board. There's 3 lay people on that board. You could volunteer at your parish level. We have restorative justice efforts going now. We have victim survivors that are involved. There's a lot of opportunity to be involved as a lay person in the church today. And the most important thing is, and nobody has to carry more than they're capable of carrying or being taller than they are, but get involved so that you see what's going on. We talked before about the priests and good touch and bad, and what, just the awareness, just the fact that you're out there. The training that we do, the virtues training, isn't designed necessarily to directly prevent somebody from abusing, but it's that when there is an abuser in our midst, we know who that is, and somebody says something. Somebody acts on it, and there's action that follows. And that's where lay people play a key role.
If I could just go back to for one moment, because the question did use the word healing. And what can people do who aren't in the employ of the church with regard to healing? If you know someone who has been abused, who wants to talk to you about it, listen to them. People want to be heard. Even as awkward and as hard as it might be to listen to their story, listen to them, because they have thought, many of them have thought that for 20, 30, 40 years, no one has ever heard them. So I encourage you to listen if you have the chance.
I would just add, we're talking about volunteer efforts here. I don't think you're going to walk over to the Archdiocese and sign a retainer agreement to be paid billable time, but so long as you're willing to do it as a volunteer, I think the opportunities are almost endless, starting with your own parish in terms of taking a leadership role and organizing a forum to have a discussion perhaps more like this, but also to involve a victim so that your fellow parishioners are actually hearing what a victim has to say about the harm that they endured. So you become familiar with that and own that. And you talk about what can your parish do to help victims that may have occurred, that may be present in your parish. I mean, that's huge. The restorative justice is one avenue toward healing. There's opportunities to provide leadership there, to participate. You may oftentimes the preferred model for restorative justice is a circle. You can participate in a circle without being a victim, but if you've got a victim within that circle, if you're an attentive listener, that makes a world of difference in terms of how they begin feeling like that they're being heard, that their voice is being heard, and that they have support. So there's a lot of different ways. Research, lawyers love to do research. There's lots of legal issues out here, in this area that could lend themselves to articles either for legal publications or law review articles. So it's almost endless if you're willing to do it as a volunteer.
One quick thing on that, you mentioned the restorative justice. Hank, Tom, and I serve on a committee, 7 or 8 of us, 3 victim survivors, only 1 priest on it, and he's here, I think, if he's still here.
I believe.
But anyway, the opportunities to do something like that at the parish level, you don't have to create it yourself. We've had more and more meetings out at parishes now where we're holding sessions. And we also have a lay advisory board that just started. It's fairly, there might be others in the country, but it's a little different here. And it's the idea of embedding lay leadership at the local level to feed into what's going on. So the priest at the parish has some say, but now there's a lay leader identified who gets to have direct communications to the archbishop. And we just had their first meeting the other day and pushed on them to listen, get in your area and say what's best for your parish or your deanery or your local area, and come to us. We have some options of things we can do in terms of restorative justice, education, healing, a lot of those things. So you don't have to create it, but if you have something at the local level, at the parish level, get a hold of any of us, and we'll try to help with that.
I'm going to try and combine a couple questions again here now. I think for all 3 of you, scandal is something the church abhors, but the secular press craves. Please comment on how lawyers can promote transparency in addressing the abuse crisis without increasing scandal or limiting it. In that vein, there's another question. What's the role of these confidential settlement agreements that we're teaching our students yet today to resolve civil lawsuits with in the context of an abuse situation? Should that be countenanced going forward?
Well, I'll take the second one first. Throw it out the window. You can counsel, you can teach them how to do confidentiality agreements, but it is absolutely 100%, and it has to be decided by the plaintiff, and it has to be with full knowledge of their attorney, and it has to be on their advice. The Archdiocese, the Catholic Church, at least this Archdiocese, will never enter into one unless it's so clearly a fully known desire on their part. We won't disclose it, right? But if they want to, free rein, I think, on that one.
How about the bigger picture question about how do you promote transparency without risking increasing the scandal?
I think that's somewhat basic. If you have bad news, tell your bad news.
Yeah.
Don't wait for the press to tell your bad news. Don't wait for a community group to tell your bad news. Get it out there as much as you can with due regard for privacy, of course, of individuals involved. But you have to tell your own bad news, and then you have to tell how you're going to fix it so that you don't have that bad news again.
And then stay true to how you said you were going to fix it, because that's another story waiting to happen if you don't. And that's critical to it all. I agree with what Kathleen just said. The news only gets worse the longer you keep it secret, and it doesn't make any. You're not acting in the best interests of an institution when you try to when you falsely believe that somehow we're gonna keep this to ourselves. That so seldom works, and because it shouldn't work.
And when you talk about the message that comes from that, it does no good to pat yourself on the back and claim what you're doing and do all that, which is some of what's happened today, I get.
Yeah.
But what Tom just said, what you need to do is actually face the brutal past, face it head on, acknowledge it, put it out there, and then you just have to shut up to some extent. And either others will recognize it or they won't. And it does no good to sound like, you know, and that has happened here to some extent. I think there's people that have said, listen, there is some hope here now.
So final question, it sort of gives you each a chance to make some closing comments here. If you were given 1 minute to meet with the Pope to give him advice on how to address the abuse crisis, what are the things you would say the church needs to do?
You know him better than I do.
A minute is not long enough to answer that question, and there are so many different things. But what is it's really important, I think, that he continues to meet with survivors, that he understands that across the world, this problem is occurring. It's not just St. Paul. It's not just Winona. It's not Detroit. It is the entire world where there is sex abuse. And I would say to him, he has to put as many resources and experts as possible on preventing abuse in the future and selecting the right people for the priesthood. And I suppose we could start talking about women in the priesthood too, but that's for another day.
I would tell him that he should give a very clear green light to the United States to be aggressive and bold and move forward. That the global issue, as important as that is, that's going to take a long time to solve, right? I mean, when you think about all the cultures, and we could get into that. But if he were to just get out of the way of what we're trying to do, and I think his heart's in the right place, but I think he sees it. I mean, imagine trying to run literally a global organization, and you got people, there's a lot of filters between us and him. But I think there are some things going on here, and I think it's actually getting there now. And I say that because sort of like government, you know, if you've been down at the legislature talking to me, government, for good reason, moves slowly. You don't want it to overreact to something. Well, I think it's the Vatican the same. I mean, when I got here, one of the greatest surprises to me was the lack of urgency in making change. You know, this idea that if we just pray and we do good things, it's all going to work out. Those are both good ideas, to pray and be well intended, but it's also good to grab it and go. And I think if our Archbishop's doing it, if the Pope would just say, you know what, I get it, United States, go. Be aggressive, and let's see where that takes us, and maybe there's lessons to be learned.
Tom?
I would say, Pope Francis, you talk about the church being a field hospital. Well, your church has created a lot of casualties on the field, and you owe a special obligation to those victim survivors still out on the field. Don't pretend they don't exist. Don't pretend they don't have harm, that they aren't harmed. Focus on providing care that is needed for them to get well. Now, that doesn't mean that there aren't some that don't need it more than others, but they all should know that the church is willing to provide them hard. And then I would also say, well, Francis, come out to the margins of your domain. Come to Minneapolis, St. Paul, and take a look at what has happened here. This can do a fairly significant turnabout within a short period of time. And I would use that to make Tim's point. Let us do what we need to do here.
Let's show our appreciation to our speakers. Thank you for coming.